many thanks for attending this afternoon panel session. Many thanks also to the organizers for having invited me to moderate this panel. We have a quite distinguished group of experts here, 3 with us in presence and 1 online. And before I introduce everyone, before we get into the discussion, I actually wanted to maybe briefly reflect on something that Professor Hestermeyer said in the morning. And that is, he mentioned that human rights and other legal communities, as he called them, are kind of, or used to be formally separate from the outset, but that there's an increasing trend of convergence. And while listening to the previous discussion and also the one with Ignacio, actually, I was thinking that in terms of history, actually, in terms of historical trade, I would say that both elements, so trade policy, that is, or trade relations between states, such as that trade law actually is. It's a state-to-state law structure, but then also the question of the individual, since human rights is very much about individual rights. Both were really part of trade from a very early moment, and I don't want to bore everyone here with I don't know, going through the Bronze Age interlinkages, which are quite fascinating, by the way. I can recommend that only. But when we look actually at the various phases of globalization, so the first one with European colonial powers going into the Indian Ocean and taking over trade routes and establishing monopolies or trying to do so, and then also with industrialization. I mean, all these globalization trends all went along with an increase in trade that led also to innovation, to technological development, but it also often really turned societies, communities with concrete impacts for the individual really upside down. And so I think it's not a surprise that, of course, after the 2 horrors of the 2 world wars, we actually arrived at, I would say that we left the lawless era of trade, and we entered the era of actually regulated trade, a legally regulated trade. So I think many of you, the panelists for sure, are very much aware, of course, of the creation of GATT after the 2nd World War. And then the second historical window, which of course was being seized, which you could say the end of history moment, so to say, in the 90s, the Uruguay Round, the Marrakesh Agreements, founding of the WTO. And that is, of course, then leading us actually to today's discussion, today's panel, because in parallel to these developments of actually the legal trade order being established, of course, also human rights concepts were kind of enshrined into concrete laws, into concrete legal rules and organizations. But of course, we do see also a further development, so to say. It's not that we just stayed with the structures as decided upon in 1994, but we also went further. And I think that's maybe something that we will actually see in the discussion today, that also not only was there kind of an increasing politicization of trade policy, but there were also certain key concepts which are, of course, key also for legal questions, such as the concept of sustainability was possibly actually increasing ever more. So I think that leads us back to what Mr. Professor Hestermeyer said, the convergence of legal communities, legal spheres, so to say. And that's what we would like to explore a bit today with the panel. I would like to briefly introduce everyone. To my left, first, Werner Zdouc. He used to be a high-ranking official in the WTO in several functions. Most notably with the appellate body. I think that's also a body we will actually hear quite often today also in all its functions, but also with the academic outreach, WTO chairs program. You also are teaching, I understand. You have degrees from University of Michigan and St. Gallen yourself, a PhD obviously, and you are still a lecturer and visiting professor here at the WU, St. Gallen, I understand. You've also been also in the Far East academically. Then left to Werner, there's Siva Thambisetty. She's associate professor for law at the LSE, and she teaches and researches on the legal protection of inventions, equitable innovation, cultural property, and the use of circulation of genetic resources. That sounds all very technical, but don't worry, she will break it down in a very tangible manner, I'm sure. And she was also involved in intergovernmental negotiations. I think you will also flesh this out later on. Then left of Siva, there is Peter-Tobias Stoll, Professor of Public Law and International Law at the University of Göttingen and Director of the Institute for International Law and European Law. Your research includes areas of international economic law, international environmental law, and in particular law of the WTO. And I understand you've also had experience, or do have experience as an arbitrator, and also with regards to negotiations also from a state perspective. And then finally, and sorry for having kept you waiting for so long, Gabrielle Marceau, she's online. I assume you're in Geneva right now. She's senior counsel in the research division of the WTO Secretariat, and she had several prominent functions in the WTO framework. Before, she was advising panelists in WTO disputes. She was legal advisor in the cabinet of former WTO Director General Pascal Lamy, and she's also quite actively academically, as I see, associate professor at the law faculty of the University of Geneva, but also at the Sorbonne and in Melbourne and others. Okay, now finally that we went through all this, we come to the more interesting part, and that is actually the four panelists and with their presentations. We thought that maybe first, in order to go through it consecutively in terms of legal structure, Gabrielle would first give you the floor. You have 20 minutes for your presentation, and then there's time for also follow-up questions. Many thanks.
Thank you very much, Chair, for this nice introduction. Thank you to the Vienna Diplomatic Academy for inviting me, and my old colleague and friend Holger in particular, his very efficient assistant. I had thought that I was not going to share the outline that I prepared for this presentation, but I think I will share it. It may facilitate for especially those who are also online. And tell me whether you see my document clearly and whether it's big enough.
Yes, I think it is. Yeah.
Okay.
Yeah.
So I think the introduction by the chair is fundamental. The links, the change of approach after the two World War. But what I'd like to do as first step, and I have some sort of 4 steps, is to speak a little bit about definitions and what I'll be talking about and the big picture before I go into the evolution and the place of human rights in the WTO. So first, human rights. Most of you in the room are more expert than I am in human rights per se, but I will always include the core labor standards of the ILO in those human rights. It doesn't change that much, but you will see that core labor is nowadays becoming more and more present in the last 1 or 2 years in the WTO. The way it was in the late 40s when the GATT, which was a chapter of the International Trade Organization, and this International Trade Organization wanted to link trade and labor standard, and employment after the Second World War was an important aspect. So labor standards, the core ones, were there, did not follow when the ITO disappeared. It was not ratified. The only thing left was this chapter of the ITO focusing on tariff. Now labor comes back. Of course, the international organization system, at least at the moment, is based on specialization. At the World Health Organization, we deal with health. At the ILO, with labor. At the WTO, with trade. And we refer to the concept of covered agreements. These are the chapter of the WTO that is a single treaty. So you have a covered agreement on subsidy, another one on agriculture. another one on services. There's none on human rights. There's none on labor. So clearly, the obligations that states commit to in human rights are not listed in the WTO as basic obligation, and therefore we will see cannot be the basis for a claim of violation. You don't go to the WTO against a country that would violate human rights. However, it has always been said that WTO is supposed to favor a sort of growth, development, which is the steps to improve standard of living, as mentioned in the preamble, and therefore human rights. So if you ask me, are human rights relevant to the WTO? The answer is clearly yes, on substance, but also in the interpretation and application and operation of the WTO treaty, although WTO is about trade. Allow me now to show a few excerpts. So the WTO preamble, that's the first paragraph that I have there, is a copy of the old GATT preamble with additions. And the additions are those listed. There's an explicit reference to not only the fact that trade relation would improve standard of living, but they should be done, this trade, this expansion of trade, while allowing the optimal use of world resource in accordance with the objective of sustainable development. This was emphasized fairly early on by the appellate body, and really, I usually tell my students, this sustainable development made or allowed the appellate body and other education tribunals to make U-turn, real U-turn sometimes on classic interpretation. And indeed, look at the statement that is there. It's a quote from the appellate body. Sustainable development was included as an objective, and it informs the interpretation of the entire agreement. And more clearly, the following excerpts, it said that it reflects the intention of negotiator, and it must add color, texture, and shading to our interpretation of all the agreements of the WTO. You know that in WTO, we talk about the various WTO agreements. These are only chapter because the WTO is a single treaty. So the reference to sustainable development has influenced the case law. I'll come back to that. But in the recent 2 years, a new punch goes on sustainable development. So you have the June 22 ministerial declaration that referred to the importance of course, the contribution to the multilateral system, the UN agenda, and here you can see again sustainable development goals, but for the first time there's a reference to economic, social, and environmental dimension. So focus on the social dimension. In 2024, this will be repeated 3 times in the following ministerial. It's important because the social dimension, in my view, drags with it equality, inclusiveness, but of course, human rights, core labor standards or all labor standards, etc. So this is the paragraph 15 of the 2024, repeating again the 3 pillars of sustainable development, and I focus on the social one. I didn't put the 3rd one. There's another one, again repeated in the context of one of the agreement, the technical barriers to trade, very important for climate, repeating the role of sustainable development for climate. So you can see immediately that human rights is floating around, and it makes sense in global coherence approach, but it's beautiful to see it in words. Human rights as an argument in negotiation exist for quite a while. For instance, in the agreement on agriculture that was started with the WTO, because before the WTO, trade in agriculture was not excluded but not perfectly covered. Now it is covered, but as says Article 20 of the agreement on agriculture, it's a continued reform process. And in this Article 20 of the Ag Agreement, you have a reference to the need to look at non-trade concern and the objective to establish a fair and market-oriented agriculture trading system. You all know how difficult agriculture is because it's not at all a north-south issue. It's extremely divisive between developing countries where you have some who have limited agriculture potential, like Africa, and others, Latino, with extremely powerful agriculture potential, and they each invoke human rights and the right to sort of grow in the area of agriculture. My point is simply that governments, when they negotiated the WTO, including the Ag Agreement, had non-trade concerns, which in my view include human rights. Now, another issue that is crucial for human rights is the issue of PPM. PPM are initial for process and production method. And traditionally in the WTO, when you have two goods that are identical, so if I take these two pens and assume that they are identical, two red pens, one is made by children unpaid, and the other one is made by a machine. In traditional GATT, if they look alike, if they compete because nobody knows how they are made, they are a like product and they should be regulated and taxed the same way. And it was prohibited, more or less, I simplify, to regulate differently two products that look alike based on the way they are made. And this becomes more and more relevant, of course, when you talk about labor and human rights, because those considerations would affect the production of products without you seeing it. And therefore, a priori, under the GATT, you could not regulate differently a pen arriving from a country when the pen is made by children unpaid and a pen made by a machine. However, the appellate body, invoking and referring to sustainable development in the context of environment, did recognize that if it's true that these two products may be sort of like and look alike and a priori be competing, governments have nonetheless the right, it's a fundamental right they have, to regulate them differently if they do so on the basis of one of the policy objectives listed in the general exception. So, let me take you now to excerpts of this shrimp case, where for the first time the appellate body opened the door to regulatory distinctions unilaterally determined by a country, which was prohibited under the GATT, on the basis of one of the A2J sort of policy. And this is what it said, word for word: conditioning market access to some requirements based on a policy unilaterally prescribed is the essence or a fundamental aspect of all the general exception. So this opened the door to things that are very relevant today for environment, but I would say also on human rights. And this continued throughout, where it was said that under the TBT regulation, under the TBT agreement that basically prohibits discrimination, also the appellate body introduced the possibility of having some regulatory distinctions between products that appear like, so long as it is based on legitimate objective, applied even-handedly, and of course not hiding de facto protectionism. So I believe that regulatory distinctions put in place in a trade regulation, but based on some fundamental human rights provision, would be fine. Also, human rights, there are some principles, and you all know the Vienna Convention and its rules on interpretation. 31.3c, for example, refers to general principle. So the general principle, if there was one relevant in the dispute, would be brought to read differently or more pro-human rights some provisions than I just listed some of the policies of Article 20 that allows government to basically violate market access rules, violate the basic trade rules to favor issues of public moral, prison labor that could be interpreted to include also some possibly forced labor, etc. Another area where human rights could come in and is coming in more and more is that in addition to having basic obligation in the WTO, each government has list of specific commitments. We call them schedules. They exist for tariff, they exist for subsidies in agriculture, they exist on government procurement and services. You can also have precisions in those schedules for trade restriction, quantitative, a series of trade measures. I don't want to bother you, but the schedules allow government to qualify a commitment. You cannot backtrack from the treaty, but you can add precision. And why not? Because terms, conditions, and qualifications are possible. Consider also human rights. Finally, I'll soon end because I look forward to exchange. There was a very important dispute after 2001 when New York was attacked, a dispute between India and Pakistan for preferences given by the EU. Preferences given by the EU to imports from Pakistan because it was a developing country. And there's a provision in the GATT WTO called the Enabling Clause that allows rich country to say imports from developing countries can come at better conditions than imports from rich countries. But the issue that came up was, can the country, in that case EU, impose conditions for those preferences? Conditions that would be based on different elements. So the EU, as you know, in its general system of preference, tells developing countries, as an example, I will accept your tables, but if you ratify the ILO treaty, your table will come in at only 50% tariff, while if it comes from Canada, it may be 30. And if you ratify also the Human Rights Convention, then the tariff will go down to 12. And if you ratify some environment convention, so these are incentives, conditions given to imports from developing countries to encourage them to become more compliant with human rights in giving them, if you want a candy, a better market access. India challenged the right of the EU to put those conditions and the type of conditions. In that dispute, EU loses that battle, but wins the war of principle, because that preference scheme was a drug-based preference scheme. The court told the EU, I don't understand why this country gets it, this other one doesn't get it. All Latino countries are in the same situation. India is like Pakistan. Your program is all disorganized. It's important, and you can put conditions if they help development, if they are objective, and very importantly, if similarly situated countries are treated similarly vis-à-vis that condition. So the EU rectifies some of its program and increase, I think now they have 18 conditions. So it's just an example, again, of where human rights is really interlinked with trade. I end in recalling that the WTO also has a trade policy review mechanism, a transparency exercise where every 2-3 years, each country is sort of discussed amongst all members. And years back, 30 years ago, this is how environment started in. Other governments ask questions. What do you do in environment in your trade policies, etc.? They have now done it in some cases. New Zealand has asked questions about labor standards, and human rights questions could come also the same way. Finally, and this is basic law, but may not be interesting, human rights treaties are facts, and they can very often be invoked by a country when it wants to demonstrate that it's coherent yes, I block importation from this country because it violates human rights. We have seen the stories of the Pakistan football balloons that are blocked because the balloons would be made by young boys. But of course, you have to be coherent. You cannot block the balloons just of one country and not the other if they're in the same situation. And in that context of a challenge, either judicial or political, countries invoke their adherence to other human rights treaties to justify trade actions that would be conditional to human rights. So I tried to share with you quickly the various angles where human rights either interact directly and upfront with trade or via national measures that are a challenge in a trade context, but also reconcile. All this, in my view, because now it's clearly established and it's one of the most important input from the appellate body. Governments have, of course, millions of obligations to respect trade and, of course, human rights. And sustainable development, as the doctrines say, is an integration principle that links everything. And in WTO, in the recent years in particular, it's extremely obvious. Thank you very much.
Yes, please.
Thank you very much.
Many thanks, Gabrielle. This was, I think, an excellent overview of all the bits and pieces of WTO law and structure, but also references to case law already at this stage, where sustainability and human rights are kind of feeding in. If there's not an imminent question from the panel to the presentation, then I would suggest we proceed. And I would suggest we proceed with you, Werner, with your presentation on human rights conditionalities in FTAs.
Okay, thank you very much. Am I audible on to the, yes? Okay, let me first thank Professor Holger Hestermeier and the authorities of the Diplomatic Academy. It's a great honor to be here at this very historic institution, especially for an Austrian. And thank you also to Robert for his very kind words of introduction. I will briefly give you an overview of my presentation. I'm this time around now not talking about WTO law, that was very well covered by Gabrielle. I will focus on conditionalities in FTAs. And before I do this, some general remarks. So I will look at the scope and coverage of human rights referred to in these FTAs. I will look at the evolving nature of the agreements that are at issue here. And then I will look at different tools and techniques, and I rely here on scholarly work done, including by Gabrielle and others, on which tools and techniques have been used to enact such conditionalities and what has worked or not worked. Before I do that, I can, I think, easily rely on what Gabrielle already said. When we're talking about human rights in this context, it's certainly warranted to have a broad definition. It's certainly not limited to classic civil and political human rights. The second covenant of the UN on economic and social rights, maybe less cultural rights, is probably more relevant. As Gabrielle already explained, a lot of the conditionalities, and you've heard it also in the panels this morning, are linking social labor rights, environmental rights, and just sustainability concerns with the enjoyment of the benefits of trade liberalization and economic integration. Different countries follow overall similar approaches, but broadly speaking, I think it's fair to say that the European Union, as was said before lunch, has the most comprehensive approach in this respect, whereas the US and to a lesser extent Canada, that are frequently making these linkages, focus more on social and labor rights, but recently also more on environmental rights. Now, of course, one could say that all these human rights are universal. It has been said before lunch, but their degree of enforcement is not. The question is then, who decides what human rights could be covered? There are elements of unilateralism and unevenness or extraterritoriality, it was also mentioned before, and some in the debate, and we have heard it also from human rights experts this morning, would also speak in favor of a separation, of a supremacy of human rights. Obviously, there's no question that human rights are binding and these instruments are binding. What is at issue here is to what extent can human rights be enforced or incentivized, and compliance incentivized through the use of trade agreements. My next point is when we are talking about human rights, developing countries are often reluctant to engaging in such treaty making, largely because of the concern about potential interference with internal affairs, because higher human rights standards, especially in social or labor rights, could be undermining competitiveness in international trade. But however, respect for comparative advantage, avoidance of abuse of human rights conditionalities for protectionist purposes, revisiting their coverage from the perspective of development, poverty eradication and inclusiveness regarding the sharing of benefits of trade liberalization, economic integration with respect to all layers of society, like women, informal sector, rural areas, or the indigenous people, are concerns that should govern the definition of these rights that are covered by such linkages. So we are proceeding with a broad definition of economic, of human rights, but also we are proceeding also with a broad definition of economic integration agreements. I don't quite like the old, outdated dichotomy of free trade agreements and customs unions. As we've heard also this morning, many of the agreements that are currently enacted, especially by the EU, go much deeper in extent and coverage and depth of integration. And they are not only covering defined regions, they're often cross-continental, and recently there are also economic integration agreements between different economic integration agreements, like the EU with COMESA or the EU with Mercosur. Maybe one slight remark to the title of the conference or the topic. It's a misinterpretation maybe to see it's in conflict or simply a matter of cooperation. What we should focus on in analyzing these FTAs and economic integration agreements is how to make trade liberalization and economic integration in pursuit of human rights standards mutually supportive, and to focus on which techniques and standards could be most successfully used in order to achieve that objective. As we know, welfare generation through trade liberalization can also have increased social and labor standards, create jobs, reduce poverty, and this has happened at a massive scale in many emerging economies. By the same token, guarantees and enforcement of human, social, and environmental rights represent framework conditions that are prerequisite for fostering development, deepening integration, attracting investment, and promoting welfare generation in a sustainable manner. So in that sense, the objective should be looking at mutual supportiveness, but nevertheless fears exist from the perspective of developed countries that the latter, that least developed countries and developing countries might use human rights lowering human rights as a matter of attracting investment and engaging in, as it were, social dumping or environmental dumping. And from the perspective of developing countries, the fear would be that the enjoyment of benefits would be used for disguised protectionism, threatening comparative advantage, especially in low-wage areas of economic activity. However, what is empirically visible is that various forms of economic integration, especially in Europe, have been going hand in hand with setting transnational common minimum standards in human rights. That is true for many association agreements or agreements leading to the accession of countries to the EU. However, it's not very clear whether the same thing can be said necessarily with economic integration agreements covering countries with different levels of development and different degrees of democratic governance. One positive example I would mention is Mexico. After NAFTA was negotiated, we faced democratization. Another example, the accession of China to the WTO has not necessarily led to more democracy, rather to the opposite. If we're looking at the most frequently, at the same time, we need to be aware that attractiveness of such human rights conditionalities will also depend on whether the human rights pursued follow Eurocentric concepts or whether sustainability concerns, development concerns, and sharing benefits in all layers of society are equally reflected in the definition of those conditionalities. Gabrielle mentioned it. When you look at the techniques that were used, traditionally preambular language has been one of the most frequently used tool, with limited effectiveness though, except in WTO dispute settlement, where Gabrielle has already explained that such preambular language has been used in dispute settlement practice to interpret WTO law in an environmentally sound way. In recent trends, what is interesting to witness is that especially the EU has used such preambular language, and also the United States and Canada, in the areas of also with FTAs covering developing countries, like in CARICOM in Latin America, also in the agreement, the Comprehensive and Progressive Agreement on Trans-Pacific Partnership, the successor agreement that was not signed by the US after Trump's election, but by a dozen other countries, and also economic integration agreements with East and Southeast Asia have increasingly used such preambular language, referencing universal standards of human rights. And we're also facing very recently, for example, even economic integration agreements within Africa or Asia, like among ASEAN countries or AFCFTA, referring to such preambular language. That's unheard of a couple of years ago. A second technique is that economic integration agreements contain provisions governing domestic human rights, social and environmental standards. In its most limited form, the technique would be to simply provide for the enforcement of existing domestic standards, whatever they may be. Other agreements more recently contain minimum standards harmonizing human rights standards, social and environmental standards, and provide also for domestic enforcement mechanisms. One example for a traditional approach of simply providing for the enforcement of domestic standards would be the side agreement in NAFTA in 1995. Recently, for example, the comprehensive trade, the TPP, provided also for minimum standards that signatories have to enact at the domestic level. One element that is also relevant in this respect, and it was mentioned before, and it's discussed in the parallel panel, is the European Community's proposal for a directive on corporate responsibility. So domestic standards don't only bind governments, but also business, they're not the classic addressees of such human rights obligations. A lot has been said about it. I limit myself to one remark. I think this approach is fruitful and useful for the future because it affects or it can reach global value chains. What we're facing nowadays is that governments, even those that want to enforce human rights standards, the global value chains escape the importing country or the initial exporting country, and maybe focusing on corporate responsibility and value chains across borders is a technique to move forward in this respect. A third frequently used technique is that economic integration agreements provide for compliance with internationally recognized human rights and social and environmental standards. Most frequently, we heard examples today about EU, Korea FTA reliance on ILO conventions, especially on the core labor standards like against forced labor, child labor, discrimination at work of women, labor union, the right to form labor unions, the right to form to collective bargaining, things that were also recognized in the ministerial declaration in the WTO in Singapore. There's also a growing number of MEAs, and already mentioned this morning, the trade and sustainable development clauses. They also have to incorporate or refer to Paris Convention and other climate change mechanisms, including national determined contributions. So there is a level of domestic national discretion involved in this respect that should also alleviate concerns by developing countries that they have to engage in obligations they are not ready to comply with. Another technique is the linkage between trade preferences and aid that was mentioned before. Finally, the last technique is enforcement mechanisms. Some of them are very soft, cooperative, consultative, monitoring and review mechanisms. They're still predominant in African and Asian economic integration agreements. Specific dispute settlement provisions are more frequent in the Americas and in the European context with countries leading towards accession or neighboring agreements, association agreements. Political dialogue, consultations and cooperation, but also linking trade preferences in a way to development and to human rights. As Gabrielle mentioned, justifiable under WTO agreements or dispute settlement practice are a technique here. Another aspect in this respect is involvement of civil society, not only business but also civil society in the enforcement through such cooperative and consultative mechanisms. The CETA, the agreement of the EU with Canada, is a very good example in this respect. And there are many more, but there are even policy aligning and common development of environmental and social policies are foreseen. Another technique would be ex-ante risk assessments or ex-ante human rights assessments. That has been done surprisingly even in the AFCFTA context in Africa in 2019. More frequently, it's a parallel system that the EU employs or also other developed countries employ. Obviously, it's most effective if it's done in advance, but also in parallel with implementation. Finally, there are general dispute settlement mechanisms that sometimes have been used. Here we'll refer to the CAFTA agreement, the Central American Free Trade Agreement, that has a dispute settlement mechanism that has been actually used in this respect, but it also highlights, and I know that Professor Stoll will talk about this later, in a way that highlights the problems related with this approach, because it was not only at issue to prove that certain labor standards were not enforced in Guatemala, it was also necessary under the agreement to prove that this was done in a manner affecting trade, so that conditions of competition would be that confer a comparative advantage on a producer or employer engaged in trade would be implicated. That has little to do with human rights enforcement and has a lot to do with comparative advantage. Interestingly enough, this ruling has led in the renegotiation of NAFTA under the Trump administration to a specific clause that provided for the reversal of burden of proof, so it could be more easily proven. And also, Mr. Werner has already mentioned the EU-Korea FTA. There was a ruling in this context where the panel under that agreement deliberately distanced itself from this kind of interpretation and said comparative advantage or an effect on comparative advantage for another employer or producer is not required in order for something to have a trade effect, for labor standards to have a trade effect. Most problematic in this context, I would say, are some of the specific mechanisms that have been developed most recently in the renegotiation of the US-Canada free trade agreement under the already mentioned this morning the facility on a specific rapid response labor mechanism, where standing has been given to also business associations, labor unions, civil society. But the standards, the rapid response mechanism can lead to preliminary measures. The suspension of trade, it was mentioned before lunch, customs would hold the trade shippings by a company that is accused, for example, of not respecting labor union rights or collective bargaining rights, before the case is adjudicated on its substance. So it holds trade upon a preliminary ruling. And in practice, highly criticized in Mexico, welcomed by certain quarters in the United States, we can see the risk of linking trade and human rights in a way that could be used for disguised protectionism or combating comparative advantage. I think I will maybe stop here. Maybe one last clause. In terms of trade sanctions, they have been infrequently used, especially not if it's not done together with other international fora. One technique employed at some point by the European Union in this respect is a so-called essential elements clauses. That refers back to Article 60 of the Vienna Convention, and certain breaches of human rights, environmental standards, or social rights are declared to be core aspects of a treaty, and if this objective is then not complied with, this is a material breach of the treaty that would allow one treaty partner to suspend or terminate the treaty in part or in full. This clause is, I think, the most effective way of imposing sanctions, but we've heard this morning in one context with South Korea that was done to some extent, but in a more recent permutation of that clause. But I will leave it at that, and maybe I have a number of proposals on how to make the trade human rights links most effective based on these different techniques, but maybe after the other speakers have spoken. Thank you very much.
Many thanks, Werner, and I think that's already a great suggestion for a question later on concerning the effectiveness, actually, in your proposal in this regard. I think you gave an excellent overview also on a kind of a broader trend in terms of where HR and also sustainability issues and objectives and criteria actually streamlined through the preamble, through the enforcement mechanism, through sanctions, etc. So I think now actually the next speaker, Tobias, would be, I think, an excellent would be complementary perfectly, let's put it this way, to both the previous speakers, because obviously at the end of the day, it depends often on concrete dispute cases for actually these clauses also to be actually invoked and therefore becoming effective. So Tobias, the floor is yours.
Thank you very much, ladies and gentlemen. I think I have something to present, but I have to confess I'm a lawyer and my topic is a lawyerly topic. So I have to report to you on a number of kind of academic discussions on how human rights can come into trade dispute settlement. And I understood, first of all, like Gabrielle did, I understood human rights to also include labor standards. I think that is, of course, there are different institutions, but it's a good idea, first of all, because there are some instruments which we call human rights, which deal with issues close to labor, for instance, a convention on migrant workers. So that has been set up as a human rights instrument, but is dealing with something having to do with labor. And the other way around, we have certain ILO, so International Labor Organization standards, which deal with indigenous people and would be understood more than a human rights issue, although they have been codified by the International Labor Organization. So I take the two together, human rights and labor standards. Second point, my topic was dealing with trade dispute settlement, and I understood trade to include the WTO, from which we heard already a lot, and also dispute settlement under free trade agreements, because all the free trade agreements are something like mini WTOs. So they also include something like a WTO dispute settlement en miniature to care for the enforcement. And first of all, I will deal with the WTO and then with the FTAs. And my first part will be something like nuclear physics. You employ a huge machine to find small traits of a material that you can use in a discussion. So basically, I will conclude that in WTO, yes, there's an academic discussion about whether human rights can play a role, but it's rather academic, like nuclear physicists are. But with FTAs, it's much more easy. But then I will try to involve you in a discussion or show you my views, because I think we have 3 steps on how we discuss the question whether human rights and trade hang together at the level of dispute settlement. And I think that's very telling and helpful for our discussion. Okay, here we go. Could you have my presentation? And then please, Chair, could you hand me over the clicker? I think we have done already much of the clarifications, and here are some starting points which I found interesting speaking in a diplomatic academy and trying to contextualize our topic in international relations more generally. The point is, of course, that the original Charter of the United Nations, so the foundation of our today's international system, had a view on economic and social development and human rights, which saw them together. And as you might know, this is the famous Article 55, which in a way defines the vision of saying that there are positive conditions for peace, and those are economic and social development and human rights, and that therefore we have cooperation in those areas. That is in Article 56. And then it is important to see that the development of the more specific architecture for economic and social governance then has seen a number of fragmentations. So first of all, under the UN Economic and Social Council, in view of those fabulous Article 55 and 56, there was a famous Havana Charter, which had been already explained by Gabrielle Marceau, and which wanted to set up a governance network for trade under the United Nations, with, of course, all the human rights coming in. And as explained very ably by Gabrielle already, it had a full chapter, for instance, on labor standards. But as you all know, this kind of an international trade organization did not materialize because of a number of developments. And so people were taking a small little fragment out of it, which was basically only liberalization in tariff reductions. And to the more, they were taking it out of the United Nations context. That was a famous GATT agreement, which then later was succeeded by the WTO. The WTO did heal a number of the shortcomings of this GATT agreement, but didn't bring it closer to the United Nations. That is one point. And didn't enlarge the scope very much in view of our interest in human rights. All this having said, I can now focus on dispute settlement, and already Gabrielle Marceau has explained to you that, of course, in the sense of decentralized dispute settlement, which we see in international relations, the WTO dispute settlement is a specific dispute settlement allocated to that specific treaty regime. So it's not a general court. It serves the purpose of enforcing and applying the specific treaty rules of the WTO. Same would later be true for the FTAs. So that explains why, as Gabrielle did put it, you can't go to the WTO in order to have your human rights enforced, because that is not the task of that particular organization. In the logic of decentralized law enforcement in the international system, you would have to go to the law enforcement institutions from human rights sectors. So to bring under one of the protocols to the global human rights instruments, you would have to bring a complaint, or under regional human rights instruments, you have your specific human rights courts, as you have them in the Americas, in Africa, or in Europe. So that is the basic logic. But within this logic, there are a few possibilities on which you could think about applying human rights in a WTO context, although WTO dispute settlement is not tasked to enforce human rights. I made the point here in saying my topic, which was given by me by my dear friend and colleague Holger Hestermeier, is specifically worded invoking human rights, and it's not about enforcing human rights. There's a small subtle difference between the two, and that is very much important. And now comes what I refer to as nuclear physics, a series of wonderful academic papers written in, I would say, between 2006 and 2016-18, exploring the potential for human rights norms to come into WTO dispute settlement in the way of application, not in the way of enforcement. And as I said, nuclear physics, in the end, all this kind of academic efforts, and a fascinating academic effort, basically concluded that there is no room. So first of all, the people were discussing that there are certain rules of interpretation for which govern WTO dispute settlement and which refer to more general rules of interpretation in international law. That is because the WTO procedural rules refer to those general rules in international law about interpretation. And those rules of interpretation also make it possible to take into consideration other international norms which apply between the parties. And this was kind of a large academic discussion ensuing after the EC Biotech case for WTO specialists here, because then the people mostly misunderstood applicable between the parties, because they understood it that those other rules, could be human rights rules, should be applicable between the disputing parties. But here we have to stick to, I'm sorry, the already mentioned Vienna Convention on the Law of Treaties, and its understanding about the word parties is the parties to the respective agreements. And that, of course, then would cause a problem, in particular for the WTO, which where not only states, but also customs territories can be members. So basically, never ever will there be a human rights instrument which membership covers all the WTO membership. So already from its very structure, it would not be possible to let human rights play a role by this particular avenue of interpretation. But then others came up and said, well, listen, if the WTO dispute settlement is enforcing basically WTO, this doesn't mean that they can't take into consideration other norms when they do their dispute settlement business. And then two famous colleagues, Joost Pavlin and later on others, have discussed on how much this could be the case. And they came out and said, well, yes, certainly if the WTO, shall I say, judges sit there, they can also pull on other law books if they would, in order to arrive to their decisions. But the point is, in each and every case, they would have to look whether WTO is not more specific. And so they found out, and Professor Hestermeyer did a wonderful piece on it in showing that, for instance, in the area of procedures, there are gaps in WTO law. And there's a good reason, and that has already been practiced, that you then take rules from more general international law to fill the gaps. But if you talk about substantive law, it's very difficult to see the gap. What is a gap? What is kind of a intentional composition of issues and rules? So, for instance, Gabrielle Marceau, in her piece on the topic, was writing, normally you should assume that the substantial law of the WTO in a way is complete. So it would be very difficult to have a lex specialis and gap type of a discussion in that area, and I would totally agree on it. And then, for instance, Holger Hestermeyer said, well, but if somebody is defending against a WTO claim, that party might rely on human rights, for instance. But the problem is there are already defenses in the WTO system, mainly the exceptions for public order, for life and health, or for security, and they might cover a lot of that. And Holger and a colleague of us, Thomas Braude from earlier Tel Aviv University, were discussing a specific issue where a country would block the importation of publications, of books, because of its internal censorship system, and they would say, well, this country did rely on an exception for the public order, but may you do so if that would conflict with your human rights obligations to free speech? Would be an interesting case, but it was the wrong country to make the case because that country is not a party to the Covenant on Civil and Political Rights. So that might be interesting, but already I think you get in kind of an understanding why I was calling it nuclear physics in comparison to the kind of the public relevance given to the issue of trade and human rights. Those very, very specific kind of legal arguments don't look really adequate. I may add a little bit. One issue in those earlier publications, you often see reference to jus cogens. And jus cogens is something while in international law we don't have a hierarchy than that you would know from national laws. We nevertheless have the understanding that some norms are so relevant that to the whole system and carry so much of a value that other norms might not get into conflict with them, to explain it very briefly. And there's a case, because there's much discussions which norms would qualify as jus cogens, but slavery does. And we have often talked, we have already also, and that has been mentioned today, legislation, unilateral legislation by the UK, the European Union, and also by the US on those what they call modern forms of slavery, like combined with the issue of conflict diamonds or slavery at sea. In all those cases, we could reflect on whether the specific nature of this prohibition of slavery, which is considered to be a human right, which is considered to have this particular high level in the international legal order, if that would do something about a WTO dispute. And my normal take about that would be no, because the exception system of public order or life and health in the GATT system and other exceptions of the same nature would allow for accommodating this particular priority that goes along with jus cogens. But there are more specific issues which we might discuss later on. There's another issue which I thought about when looking into EU's economic sanctions legislation, because recently you always find a section on sanctions and human rights, explaining that the EU's measures would be limited in case that they would carry the potential to contravene human rights obligations of be it the EU or the member states. And I thought, does this make a bell ring to me? And it's very difficult to think of a case, but a case that I could think of is that in WTO retaliation, so the famous trade sanctions, one country would limit exports of a human rights sensitive product, which might be foods, agricultural products, or agricultural input products like fertilizers. And if, as a sanctioning state under WTO dispute settlement, you would do so, this might conflict with human rights norms. And there are several ways in which Article 22 of the dispute settlement understanding looks into the matter on how to decide what kind of a sanction to take. And possibly there would be flexibility to take into consideration human rights concerns. But this is not a final statement, but more as a hint that more discussions might be needed quickly on this particular point. Well, so far I have spoken about nuclear physics. You invest $20 million to see a small trade, and Free trade agreements are totally different for one simple reason. They incorporate labor standards by reference to the ILO standards and by making them a part of the FTA legal system. And more, they also take into consideration human rights involved in the larger topic of trade and gender. So, for instance, in recent agreements, you see a reference to the UN Convention on the Elimination of All Discrimination Against Women, the CEDAW Convention. We have it particular, for instance, in EU New Zealand, as a consequence of pioneering work by Chile and Canada earlier on. And that shows that more and more we discover the potential of free trade agreements to work as a facilitator for human rights. So I have told you already that part of my story was nuclear physics, because there was not really so much of a result. In the WTO system, there's hardly any possibility to take into consideration human rights in dispute settlement. So you ask yourself, why has it been such an academic topic? It should, in my view, also be mentioned that we also still have a political arm of the WTO system, where we had developments in the area of medicines and the TRIPS agreement, and for instance also the Kimberley waiver, covering products which have been produced by way of slavery or other treatment. But why I'm telling all these stories? I think there are basically 3 steps of how we discuss human rights, trade, and dispute settlement. I think the earlier academic discussions, which I called nuclear physics, come from a time, and I'm happy for for the EU ambassador to tell us this morning that we had this wonderful time of multilateralism after the 1990s or 92 or 95, when it looked that in a Hegelian way, our international Bill of Rights would progress anyway and without any interruption. And then in this beautiful picture, there was this WTO, which was considered to be ignorant, to be less aspirational. So I think the discussion, the discourse on human rights and trade comes from that perspective very much. When the WTO as such was considered to be something, a stumbling block in the way for further realization of the International Bill of Rights. And then we have a second period or a second layer where we are talking about FTAs, where exactly those deficient trade rules and regimes that we were criticizing so much beforehand now are used as a helper to enforce human rights, whose genuine enforcement instruments, as you know, are not very effective. So now we're getting, trade is looked upon totally different. Now we understand it as to be a facilitator for the enforcement of labor standards and human rights, but the downside of it is bilateral. So you have the bargaining power and the inequalities in the world totally play out. And of course, now we have a third step, which is that, for instance, the European Union, but for instance also Germany, the UK, or France, go forward and enact unilateral measures on trade, which also cover labor standards and human rights. And that is certainly also kind of a different understanding about the balance of powers and equality in the international system. And ending with the chair's remarks of the individual, I would say what we would need would be a new discussion about justice and rights in the international economic governance. And I don't see it so far, particularly the chair's very welcome remarks on the individual. Because I think the individual in the WTO is not served very much, and that is unfair if you consider that also producers and traders have human rights to their property, to be able to trade, and that is because the WTO is not only for multinational nationals and rich companies, it's also about the farmer in Uganda or the textile producer in Thailand, which are affected if they do their investments and bring economic and social developments to their villages and places. They are affected by kind of trade restrictions which other countries may impose. So sorry for taking so much time. Chair, thank you very much.
Many thanks, and it's a fault on my side of handling the moderation, of course, in terms of time management. Indeed, we're running a bit out of time, even though since we started late, I would suggest that we also go slightly longer than 3:15. I think this was really an excellent arc now, actually, from the principles and legal details to actually the broader development of how trade policy in relation to human rights is actually being perceived. So maybe at the very end, we can actually go back to the very last slide. But now we're coming to Siva, and I think it's actually perfect to round this up, because most of you are probably aware that, of course, WTO law not only covers, let's say, the classical elements of trade aspects, but it's a much broader set of rules also covering various other areas of economic activity, let's say, whether it's public procurement, but especially also when it's coming actually to IPRs. So this is a bit more specific now, I would say, but I think an excellent addition to the overall discussion here. Siva, the floor is yours.
Thank you, Robert, and thank you to my co-panelists, because I feel like I've learned a lot this afternoon. Oh, yes, of course.
I don't hear
Hi,
anything.
can you hear me? Okay.
Yes.
Okay, so this is a panel where we're not being very classic, as we've heard. We heard about human rights that are not very classic, dispute settlement that's not very classic. And I'm going to talk about genetic resources that are not classically seen as being part of the trade framework. To make a confession, when Olga asked me to speak, I was in two minds about what I wanted to focus on. So in what's typical for me, I've decided to do both. So this is going to be a presentation in two halves. I'm going to start with the question of access to medicines. And I'm going to then take you through a narrative into different negotiating environments, negotiating contexts on genetic resources. And today, we've just agreed the newest treaty on genetic resources at WIPO on the disclosure of origin of genetic resources. So we already have something to celebrate. So I start with, we can start with Olga's question about conflict or coexistence in terms of human rights and also IP. In the academic literature, this question of human rights and IP has preoccupied a number of academics. Lawrence Helfer, for instance, lays out this sort of mapping of coexistence, conflict. And Rochelle Dreyfus from NYU talks about the paradox of human rights. And here I take off from where Tobias left it in terms of private rights holders. Right? So IP is also a human right. But when we talk about human rights, we mostly consider the negative impacts of IP rights that are held on human rights. And in fact, the human right to IP was brought to the UN, the Universal Declaration, by Latin American countries that wanted to protect labor standards, that this was an outcome of intellectual labor that needed to be protected. So we are where we are with that. And of course, you can point out that corporations that hold most IP cannot really have human rights. Intellectual property rights are generally of short, they run out, they're of short duration, so they're not, again, classically a human right. But that's a whole academic sort of topic. From here, I want to take you to, so I'm going to here use some of my own papers to show you the development of my own viewpoint on this issue. So in 2019, I wrote a paper on improving access to patented medicines. And I argue there that human rights are actually getting in the way of resolving this question of access to medicines. And of course, it's not just a provocative title. Why would I make that argument? So when you think of the patent system, of course, I don't know what you think of the patent system, but we often think of the system as something that is optimally set up, that is institutionally really well designed to govern these rights that we then give to patent holders. The truth of the matter is that the patent system has developed over a number of historical contingencies. There are a number of adaptive coping mechanisms in the system, which means that our design of patent rights are really quite a pastiche of different ways of solving different kinds of problems. So just to give you an example, for instance, when we talk about disclosure, so you get a 20-year protection to your invention in return for disclosure of information about the invention. Now, what is the quality of that disclosure that's required? It's actually very little. You don't have to say very much about your invention at all to get that 20-year protection. Now, this has caused a lot of problems, for instance, in genetic sequences where you have to actually disclose all sequence information, but when it comes to software programs, you don't have to disclose programming code. And this has to do with what particular patent offices saw at that time as the problem that needed solving. So far from being a well-designed right, patent rights are quite dysfunctional in their own way. Patent offices that govern these rights often function as special interest organizations. What do I mean by that? I'll give you an example. The European Patent Office, for instance, in a case, diagnostic methods case, says it's the role of the European Patent Office to grant patents. Can anyone spot the mistake in this or the inaccuracy of this? Yeah, go ahead. Exactly. So the EPO sees itself as the body that grants patents. Of course, it's the body that administers the European Patent Convention, that has exceptions and exclusions that also have to be implemented. So, and then combine this with the fact that the EPO has very little oversight. There isn't a court sitting over the European Patent Office that looks at its standards of examination, for instance. Another point, the patent holders often drive the patent prosecution process. It's entirely done on documentary review, so you present documents, the EPO looks at the documents, so you can present what you want in terms of prior art to the patent office. So, I mean, I can go into more of this, but there's quite a lot of dysfunction in the system. Now, it's not just the dysfunction. Just look at let's look at the sort of institutional design of the system. Public interest, or the interests of you and I, are filtered through the interests of the patent holder. So the system works on the basis that if you look after the patent holder's interest, our interests are looked after. Of course, this is not entirely true. There isn't a full juxtaposition between the interests of the patent holder and the public interest. Now, why do I say this? There isn't really a notion of harm in patent legislations that is not harm to patent holders, right? And this means that if you want to address certain outcomes from the patent system, it's almost impossible. The patent system does not exist to bring out equitable outcomes. It exists to protect the interests of the patent holder. Now, this is, of course, a very sclerotic way of addressing society's problems, the social questions. So not just do we have growing incremental dysfunction, we also have an institutional design that is arguably not tailored to work in public interest. And we adopt what is a sort of a trickle-down technology model, if you like, through the patent system. Now, this picture gets much more complicated internationally. So a patent right is a territorial right, but internationally through the TRIPS agreement, it also means that when you have a crisis, and you all know which crisis I'm talking about, we again rely on the patent holder to coordinate the demand and the supply of particular products. I just wanted to give you an example. There was this morning, Nicolo mentioned that he wanted to ask an expert in the room about AI patents. So I thought I'd put this slide up. When we think of the patent right, we think of this right as historically entrenched and therefore optimal. What we have are a series of different kinds of patent rights, because as new technologies develop, the EPO or the patent office decides whether we will grant a patent or not, and invariably they do decide to grant patents for new, unprecedented, emerging technologies. These are two examples of the kind of technologies that now you can get a patent on. The material in green, classification of digital images. You can get a 20-year exclusive right for that. Do we need it? I don't know. How many of you use Word 98? Do you need 20-year protection for Word 98? Many of these technologies will become obsolete in a few years. Therefore, it's really arguable whether you need a 20-year duration of protection. The second one is an example of machine learning, where you have a classification method that can also be technology and be exclusively protected. In my view, and I think in the view of a lot of other experts, we really have to consider whether this is actually blocking the diffusion of innovation. Okay, so going back to my argument of why would I say that the human rights movement is getting in the way of access to medicine. And you can look at human rights and also competition policy, for instance. What these bodies of law do is to try and remedy the ills of the patent system, but outside of the patent system. So there's a displacement. There's a displacement of the solution to outside of the system. You take something and you make it exogenous to the system where the location of the problem is. And the argument that I was making in that paper was to say we would be much better off focusing on the design of the patent right. And when we leave it to human rights to correct these ills, to remedy these ills, we are not paying attention to the cause of the problem. And this, in my view, it means that we're going around in circles. Of course, if I was writing the paper today, I would put in a section on a very important nuance, which is that the human rights arguments do work domestically. To give you a recent example, the Health Justice Initiative, which is a wonderful South African advocacy organization, has gone to constitutional courts in South Africa to ask for vaccine contracts to be disclosed. And what we on grounds of public interest, and what we find there is that Moderna was negotiating $45 price per vaccine dose with South Africa when the price for EU was $25. Now, this information would not have been available but for court decisions like that. And therefore, human rights arguments really count domestically. Most of my argument is about what happens internationally. And then, of course, we had COVID. So the term that's used for the unequal distribution of vaccines during COVID is vaccine inequity. I think the WHO, Tedros has also referred to it as vaccine apartheid. Now, apartheid is a very serious term. It's a peremptory norm in international law. It's a crime against humanity. These are serious words. Did it have any factual resonance? Of course, it does. By the summer of 2021, 10 countries had used up 75% of the supply of vaccines. And low and middle income countries had just little over 1% of available vaccine doses. There's also current mathematical modeling that shows that with earlier or greater availability of vaccines, we could have avoided 50%, right? 50% of deaths in 20 low and middle income countries that were part of that study. Now, these are huge numbers. Of course, the question then becomes, was the inaccess a problem of the patent system? Did the inaccess happen because of the patent system? Now, of course, opinions vary, but I think now it's clear, looking back now, you would have very few people would go on a stage and say this is not because of the patent system. In fact, we have vaccines because of the patent system. And without the patent system, we would not have had vaccines. The arguments against that are legion. A lot of public sector money went into vaccine development. So a lot of the risk of innovation there was underwritten by public sector funding. I think in the US, Moderna got something like $2 billion from the US government. It didn't just stop with money. The US government also protected companies that would develop vaccines from potential litigation by granting close to 60, in effect, compulsory licenses to existing technologies. So there was a lot of rallying around to make these vaccines available. What did not happen, and this is a paper that I co-authored with colleagues in 2022, where we looked at the TRIPS waiver argument. We looked at for and against the TRIPS waiver argument. I'm assuming you all sort of know what the TRIPS waiver argument is or was, and I can take questions later on that. So the question of, is this about patent rights? One way to answer that question is to ask, why were there not more non-exclusive licensing to vaccine technologies taking place? In effect, it's free money. You would get royalties, but somebody else would manufacture the vaccines. Why did that not happen? And one of the reasons, partly speculative, is that it's not the mRNA technology that was at the heart of some of these vaccines. It's not just about the product. It's a very important platform technology where transfer of that technology is potentially loss of control over that technology. And therefore, competitively, it made no sense to make that transfer. The WHO hub that was set up was also not helped by any of the vaccine manufacturers with technology. The technology transfer simply did not happen. Of course, there are arguments that say, you can't expect developing countries to produce these vaccines. These are complicated, sophisticated technologies. Again, these were countered in real time, these arguments. The New York Times, there were other academics who came out identifying manufacturing units that could manufacture these vaccines quickly, but were sort of ignored. Okay, so that's about technology transfer. Now, what happened during COVID has led, I just put up 2 points I want to raise there. Professor Anne Orford in 2022, in her Michael Kirby annual lecture, she says, she calls for a termination of the TRIPS agreement. And partly, beautifully, elegantly made lecture, which is also now written up and published by Brill Publications, largely on the basis of 2 arguments. One, that material conditions of the TRIPS agreement have now changed. And 2, that the TRIPS agreement is simply not capable of addressing the social question. And that we need to put the social question of access to technology and inventions back on the table. And Colombia recently, last week, 10 days ago, has asked for a comprehensive review of the TRIPS agreement based on quantitative data. Let's see how much of, let's see how how much the TRIPS agreement is actually helping producers of technology in developing countries, for instance. Now, I think these two are quite important signs, I think, of a major rethink around some of these questions of IP and access to technology. My perspective on what happened during COVID is that vaccine inequity is not an aberration. It was not an unintended consequence, but this is exactly how we expect the patent system to work. And it worked as we expect it to work, which is that it protects the rights of the patent holders. Now, if we want anything different, we have to open up the black box of IP norms. And what way is better, to check or to see what we might do than to go to negotiating context. And this is where I want to bring in genetic resources. So as I mentioned, genetic resources are not typically considered under the trade framework, but the Convention on Biological Diversity, which gives sovereign rights to plant and animal genetic resources to countries, has observer status at the WTO. I think there are a couple of requests still pending, and obviously the intersection with the TRIPS agreement, IP rights, brings it under the WTO in a non-classical way, if you like. And these are two papers that, again, I've written. I did not mean this to be really hagiographic about my own publications, but I'm trying to bring in the sort of arc of how I come to this problem in this way. So there are maybe 4 different contexts where genetic resources currently are relevant. One is the BBNJ, the Biodiversity Beyond National Jurisdiction Treaty, the latest UN treaty from last year, which gives a governing framework over genetic resources collected from the high seas, which is to areas where there is no sovereign rights, which is actually about 60% of the Earth's surface, which is a huge area in terms of biodiversity, right? And then the ongoing pandemic negotiations, which might have collapsed while we were on the panel, don't know, it was on knife edge, where the question is of pathogen access. So what happens, I'm talking particularly about Article 12, when you want access to pathogens of pandemic potential from a, let's say, a biodiverse rich country, what would that country, when that country contributed the pathogen to the system, what would that country get in return? Now, SDG 15.6 talks about equitable benefit sharing from the utilization of genetic resources. And again, we've spoken about the sort of ecosystem of human rights that includes standards of living, sustainable development goals, and we have a specific sustainable development goal on benefit sharing. So I acted as advisor to the G77 plus China group in the Oceans Treaty negotiations last year. So some of my perspective is informed directly from negotiating or being in the room where these issues were being negotiated, and also now currently working on the pandemic treaty provisions. So there are 5 things, I'll go through this very quickly, that I want to bring up that are trends in these negotiations that I feel work against human rights in these negotiating contexts. And I would like, if you want to be hopeful and look to the future, I would like developed countries to think more carefully about some of these positions that are taken consistently across these negotiating contexts. So very quickly, one is, as a negotiating tactic, distinguishing between physical samples and genetic information. Even in the first article that Francis Crick wrote about the structure, the helical structure of DNA, he talks about information. The information is where the value lies. And therefore to say, look, we can govern physical samples but not information, is to say we want to leave what is valuable out there for private interests to exploit. The second sort of position that's taken is to leave sequence information open access. Now, open access is not equitable if open access also leads to proprietary information. Then the parties or the entities that have the capacity to take advantage of the open access will definitely benefit more. And the open access movement in this context has become a way of translating or universalizing national patrimony over genetic resources into something that is far more dissolute or far more diluted. The third point I want to sort of bring here is that there's a sense in which I think we have to be very clear, biodiversity is no longer free, right? And one way of thinking about that is that we don't go from biodiversity we think of as replenishable and an infinite resource, but apply patent rights to it and it becomes much more scarce. What we really need to focus on is the technological prospect. That is very scarce once you're able to get a patent on it. This is something that comes up, and this is a boogeyman in these negotiations, which is traceability of genetic resources. Why is this important? Where the genetic resource comes from is about rights and obligations that are attached to those genetic resources. And if you cannot monitor where your resources are coming from, then you have no way of looking at who gets benefits out of the use of these resources. Now, it's not just about patents, it's not just about IP. Monitoring the flow of these resources is an important part and cannot be achieved without some form of tracking and traceability. If I can take, maybe I'll just, I have a joke from the Oceans Treaty. One of the things that the Oceans Treaty achieved is something called the batch identifier. So for the first time, the Oceans Treaty has come up with a techno fix for one of the most long-standing problems in biodiversity governance, which is where do these resources come from? And this is in the form of what's called a standardized uniform batch identifier. So the joke is this, that, the batch identifier goes into a pub, the barman says, where are you from? And the batch identifier says, precisely. So that's the whole point of the batch identifier. So I hope you will not forget that ever again, because this is an important win for multilateralism. And I was in that room when the batch identifier was agreed. It was a very, very exciting couple of hours to see the coming together of minds on this. But in the pandemic treaty negotiations, the opposite is being, opposite position is being taken, no traceability, no tracking, although the PIP framework, the influenza framework, has tracking in it. It has tracking in real time and traceability of pathogens in real time. My last point is about voluntary technology transfer. Now, some of you will know that Switzerland put in an amendment to UN General Assembly resolution on the 1st of May, or maybe it was the 10th of May, talking about technology transfer, saying it should be restricted only to voluntary technology transfer. This is what we had during COVID. Voluntary technology transfer does not work. Which company is voluntarily going to give up its value? Right? We have very little public ordering transnationally of private interests. In a country, domestically, you could use procurement laws, for instance, modify private rights holders' behavior. It's impossible to do internationally. And in the pandemic treaty, they're really pushing for, pushing for voluntary terms of technology transfer. I can leave this here on the screen, not go into it. These are in my, I wrote this late last night, sort of, what do I want in the future? I would like these 5 things to hold as negotiating edicts when we talk about genetic resources. So just to give you an example, the WIPO declaration on disclosure of genetic resources that now compels patents, you have to say where your patents, your genetic resources come from, is 10 pages long. It took 20 years to get those 10 pages. So that's about 2 years per page. So I think we could save a lot of negotiating time and resources if we can just sort of follow these 5 edicts. Sorry, apologies for going over.
Many thanks, Siva. I think this presentation showed perfectly how trade law and human rights aspects are actually also not just intertwined, but actually also related to to other bodies, other legal bodies, and other international organizations. And I rather do not reply to the TRIPS question from my formal capacity, but luckily I'm here only as a neutral moderator, because obviously there are very sound arguments that would go the other way. Okay, we have a problem now. We have 5 minutes left till probably the other the other panel, which will take place. It will probably kick in the door. So, but I still want to pose questions to you, unless there are actually questions in the audience. Very short, 1 or 2. Okay, then I will maybe pose a question, and feel free to pick up the question on your side. And that would be Peter-Tobias very much underlined invoking human rights, of course, in DSP disputes. And especially here, Article 20 and the general exceptions are, of course, key. Would maybe a question to both you and Gabrielle, and please reply very, very briefly. Would you argue, since also what the common, what is commonly understood as sustainability actually has broadened over the last 3 decades, does it have an impact on how these specific general exceptions are actually being invoked? Thinking about also that maybe the environmental aspect of human health has actually become more important, or also thinking about the entire scarcity of resources issue. So 2 of the key exceptions which often be invoked. Do you see a possibility also, therefore, for both human rights and also sustainability concerns broader, actually becoming more important through trade law invoking? Maybe first, Gabrielle, since you actually spoke at the very beginning. And
yes,
please be very
hello.
brief and very precise, if possibly.
Yeah. Thank you for your question. The answer is clearly yes. I think the sensitivity of the general population and governments to sustainability brings together human rights. And it's the pandemic that made us realize this. It's climate. It's the recent judgment of ITLOS and all that. This modifies our approach in silos, and trade and human rights is closer. I would like to add just one point. In the WTO system of rules, you have those exceptions. Yes, very important. They have been read differently, more broadly, and they have been read in the first dispute of all. Gasoline, the appellate body, said Article 20 referred to rights of governments. Never under GATT did anyone talk about rights. It was more about obligations and protectionism. But the last point is that we have a beautiful chapter called TBT, Technical Barriers to Trade, that transform the exceptions into conditional rights. And I'll end when repeating what I tried to say, that when the case law recognized the rights of government to implement regulatory distinctions based on legitimate objectives, such as human rights, this was a fundamental transformation from the old GATT days 30, 40 years ago. But I fully support what you said. Thank you.
Okay, many thanks. Tobias?
Thank you. There's a rule exception system in the whole WTO, which allows what we nowadays call a right to regulate. Yes, and that's perfect. The only problem with it, first, when we rely on it, nobody can really see that states in this way accommodate their other international obligations under international agreements. So it's not that the international agreements are brought to accommodation at international level, but it's rather that in the WTO, individual member states can decide to use their flexibility to comply with their other international obligations. So it's not really kind of a systematic way to do it. And the other point, it is a right to regulate and no duty to regulate. So no enforcement power of those other rights and obligations from other international regimes.
Many thanks, Tobias. I think very pertinent that we also mentioned the concept of right to regulate, often also referred to as policy space, which is of course becoming an increasing question also when it comes to environmental measures taken by countries. Okay, and now maybe one question to both bundle you together, so to say. Effectiveness. You mentioned effectiveness in terms of what your proposals would be in terms of enforcement of human rights via FTAs. Of course, we also understood the caveat from Ignacio early on, often the allegations of neo-colonial behavior when we talk about EU unilateral decisions. And maybe also effectiveness, Siva, in your field, very quick, what would you think, what would you expect in terms of a further, well, WTO reform is of course much in newspapers, we're all realistic what can be done, but in terms of, let's say, the WTO law, TRIPS, which is most relevant for your research, in 2 sentences, what would be your wishes? And maybe Siva starts and then Werner closes. Thanks.
So I think there is a convergence across different fora towards the sort of 5 edicts that I mentioned. And I think what I would hope for is that this is a wave that grows and grows in a number of different contexts. In the pandemic treaty, they referred to the Oceans Treaty in a number of ways. Today, we've had the WIPO text agreed. So let's hope that this is going to be a groundswell of movement towards more equitable behavior when it comes to the use and circulation of genetic resources.
Okay, Werner?
Well, thank you. Well, I would have a lot to say about the last presentation too.
Sorry, I don't hear you.
Oh, sorry. I need to switch it on. So now I think, Gabrielle, it works?
Yeah.
Yeah. Maybe one point would be, it's quite important to have equity, to have benefit sharing and equitable access. But I think the creation of group property rights may be inevitable, because I don't see how technology transfer would otherwise happen, with the caveat that maybe patent rights in certain areas should be more limited, like in medicines. Turning back to the FTA question, maybe I'm going to limit myself to 3 points. One is, one has to revisit the notion of human rights that are being covered in these conditionalities from a developing country perspective. Again, welfare sharing of the benefits of trade integration and liberalization. Issues like food security or inclusiveness in terms of sharing of benefits with disadvantaged layers of society would be aspects that have to be taken into account, and I think that would de-ideologize the whole debate on whether human rights linkages are acceptable. It will be important to have more minimum standards rather than preambular language or simply enforcement of domestic laws as they exist, because as was said many times today, human rights are universal. A lot could be gained from ex-ante risk assessments and impact assessments. And then maybe as a last point, sanctions are probably not a way. Linking preferences to GSP-type preferences to aid, to incentive structures are the more effective means of affecting behavior, and they also solve, going back to the PPM problem, that those countries or companies that comply with certain standards are not subject to sanctions too. And maybe a very final point, involvement of civil society and business associations. I also personally believe that involving parliaments in treaty making is an important aspect that has led to a lot of human rights enforcement drive, for example, in the European context, and where this is not happening, like in the North American context, we are shifting back to using, to the examples I mentioned in the renegotiations of NAFTA, where human rights linkages have been more used in order to combat the comparative advantage of developing countries. I stop here. Thank you.
Okay, many thanks. Dear panelists, thanks for your excellent contributions and thanks for your patience. And I wish you an interesting remaining afternoon today and also exciting sessions tomorrow. Thanks.
Thank you.
Bye, everyone. Thank you.